Hello, everyone, and welcome to today's seminar, which is looking at underpayments at work. And so we'll be going through a few different things to do with underpayments. As a brief introduction, my name is Sari Feldman-Gabay, and I'm a senior solicitor at Redfern Legal Centre, which is a part of the Employment Rights Legal Service. Before we kick off, I'm going to just acknowledge country. So I'd like to acknowledge that I am Teams calling you all today from the land of the Gadigal people, and acknowledge that sovereignty was never ceded, always was, always will be Aboriginal land. I'd like to pay my respects to elders past and present and extend that respect to any First Nations people who are joining me today online. So the Employment Rights Legal Service is a free employment law service which provides advice and representation to migrants and vulnerable workers across all of New South Wales. So we have a particular interest in assisting people who are in rural areas and might not otherwise have access to legal information, education, or advice. We are a collaboration between Kingsford Legal Centre, Inner City Legal Centre, and Redfern Legal Centre. So together we make up the Employment Rights Legal Service. Before we jump into, I guess, the substantive material that I'll be discussing today, the chat function has been disabled, but if you have any questions, please put it in the Q&A section, and we'll address all the questions at the end. But I do have our media and comms worker here who will monitor if there's anything urgent that gets put through to the Q&A. But yes, that is how we're going to run today. So a quick, I guess, reminder that today I will be providing you all information. It's not legal advice. If you need advice that's specific to your situation or to the situation of someone that you know, then they do need to speak to a lawyer and get discreet advice about that issue. So today I will be talking about legal concepts and issues, and we'll run through a case study as well. But it's important that you don't rely specifically on anything that is said today as being legal advice to your situation or about your situation. So today, the talk can be broken up into three broad categories. The first thing is we'll be discussing what actually is an underpayment. The next thing we'll be discussing is how do you work out your correct pay if you think you've been underpaid. And then the third thing is what do you actually do now that you know you've been underpaid? What are the steps that you can take to try and remedy that? So what do underpayments look like? It's important to know that underpayments look like lots of different things, and they're not usually the same for one person to the next. It can be a combination of lots of little things that together amounts to an underpayment, or it can be one big thing that an employer is doing that is an underpayment. So I guess I'll run through a couple of examples of what that might look like. So on the far left of your screen, you'll see that there's full payment of entitlements, and that's someone who's getting everything that they're entitled to. Just below that, there's unpaid entitlements. So these are discrete unpaid entitlements that you're supposed to be receiving that you're not. And so that commonly can look like not being paid superannuation on top of your wages. So the hourly rate that you're getting is correct. You're paid for all your hours of work, but you're not paid superannuation on top of that. You're not paid for taking leave. So you take leave, your employer allows you to do that, but you're not paid for it, or you're not paid at the correct rate for it. So when you take annual leave, for example, most people are entitled to a specific percentage on top of their wage called annual leave loading. Sorry. And a lot of times employers won't pay the loading. So they'll pay the normal amount, but not the loading. And that is an underpayment. Another thing is long service leave, redundancy payments. So if your employment ends by way of redundancy, you're entitled to a specific payment for redundancy, not just your notice. And then the other thing is tax. So if you're being paid cash in hand and there's no tax that's being paid to the ATO on behalf of you or in relation to your wages, then that's a liability that you might accrue and the ATO might then come after you. I apologize. The next thing is sham contracting or incorrect employment status. So sham contracting is when an employer will treat someone like they're an independent contractor when actually they're an employee. So the difference between employee and contractor is, well, there are a lot of things that make the two different classifications quite distinct, but a lot of times employers will rely on the fact that they've told someone that you're an independent contractor and they'll get them to give them an ABN and it be invoiced to be paid. And that will be the only thing about the arrangement that looks like it's an independent contractor arrangement. But for all other intents and purposes, the person is actually an employee. So an employee is entitled to minimum entitlements as set out in the relevant legislation and modern awards that we'll come to in a little bit, whereas an independent contractor isn't entitled to those things. So that's a private contract between two parties and the independent contractor can agree to anything. So it's a common way for an employer to pay someone less than they should be entitled to by calling it an independent contractor arrangement. The next thing is telling someone that they have a different or classifying someone as a different employment status. So that might be telling someone that they're a permanent employee when in actuality they're a casual employee and not paying them the extra loading, so an extra percentage that you get on top of your normal wage if you're a casual employee. Another way that underpayments can manifest is by misrepresenting entitlements or workplace rights. So that could be like telling someone, if you work here, you have to pay for your uniform. That's something that everyone has to pay for. And you also need to pay us to get your uniform laundered every week. So you're going to need to pay us $50 every week for us to maintain your uniform. And then that's deducted from their pay. So there's a misrepresentation about what you have to and don't have to pay for. That is an underpayment and you shouldn't be required to spend any money or have any money deducted from your pay in order to carry out your work. The most common way that an underpayment manifests, in my experience, is the next little point, which is incorrect wage under the award or contract. So that will be where an employer is just paying less than the applicable minimum entitlement as set out in either the modern award, which we'll come to, or in a contract. So a minimum wage might be, for example, $30 an hour, but you've signed a contract which says that you're going to get $40 an hour, but then your employer ends up paying you $30 an hour anyway. So that would be an underpayment in relation to the contract, versus if the minimum award rate is $40, but you agree to $30 and you're paid $30, even though you've agreed to be paid $30, it's still an underpayment because the applicable legal minimum is $40 an hour. The other way that this manifests is people not being paid the correct rates for work that's performed at certain times. So if you perform work really late at night, on the weekends, on a public holiday, or if you're working overtime, so more than 38 hours a week, if you're a full-time employee, then you're entitled to be paid a specific rate for those hours. So it's usually quite a bit more, quite a substantial increase than your ordinary rate. And I see a lot of clients who get paid the same flat rate, regardless of what hour or what day they're being required to work. The next thing is employees not being paid for all of your hours worked. So that would be a situation where an employee is told that we expect that you're going to get all of your work done in 8 hours, but if you don't get your work done in 8 hours, you need to keep working until it's done, but we're only going to pay you for 8 hours of work. And so you work 10 hours, but you're only paid for 8. Another example, which is kind of the worst example, aside from not being paid at all, is when you're only paid occasionally. So I see a lot of clients who get really sporadic payments from employers. So only when the employer has money Do they pay you? It's not fortnightly or monthly. It's very random. It's usually not the correct amount anyway, but it's just enough to keep you sort of interested and reliant on that. And then, of course, not being paid at all is the most serious example of an underpayment. So a couple of red flags that we see that not necessarily, it's not a rule that there will be an underpayment going on if you see these red flags, but they're good indicators that there might be something untoward going on. So the first thing is getting a job from Gumtree or a WhatsApp group. So I guess the things that are red flags that flow from that is that there isn't usually clear information about who the employer is. So what's the actual legal entity? What's their ABN? And it's hard to have accountability when you don't know exactly who the person is or who the entity is that's employing you. So if you have issues, who do you raise that to? What happens if you raise it on that to the person in the WhatsApp group but they block your number? Then you might be left without very little recourse. The next thing is being paid when your boss can pay you. So the obvious issue here is that you're not being paid in accordance with minimum entitlements. So depending on which award covers you, or if you're not award covered, there are rules about frequency of pay. So most people in Australia have to either be paid every 2 weeks or every month at a minimum. So if you're having your pay being regularly missed and only paid when your boss can pay you, that's an issue and that's unlawful. We often find that there is often respect or trust that's being manipulated in these situations. So it might be an employer that you know, or it's someone that knows a friend of yours, and that person might take advantage of the trust that you have in order to keep you in a situation which is actually unlawful. The next thing is being paid cash in hand and getting paid below the minimum hourly or below the minimum legal rate. So oftentimes you'll hear, well, I was being paid $15 cash in hand and I was told that that was better for me because it meant that I wouldn't have to pay tax on it. Firstly, if you're earning $15 an hour, you might not even have any, or if you do, it'll be a small tax liability if you're being paid minimum wage, that is. Oops, is that still up there? Sorry, I'm just having some technical difficulties. Yeah, I think it's good now. Sorry about that. So the first issue is that you're being underpaid per the national minimum wage. There isn't any tax that's being paid on your behalf, which might seem like a benefit to you, but then the ATO might come chasing you for a debt when really it was the employer that should have been making those payments in relation to your wage. And superannuation. You're not getting any superannuation if you're getting cash in hand. And superannuation is a payment on top of your wages. So it's not included in your wages. It's a payment that is extra to your wages. And it's a really important type of payment because it ensures you have security when you're older and you're no longer working. The next thing is not receiving pay slips. That's a pretty big red flag. So the question, I guess, the immediate question is, why doesn't your employer want to give you pay slips? It might be they think it's administratively difficult, or it might be that they're actually hiding something from you. So it's really difficult if you don't have a pay slip to check if your pay is correct, to understand how many hours you've been working. So let's say you've been working somewhere for 5 years. It's really difficult to go back 5 years in your memory and to think, actually, how many hours did I work that week? So it might be fine for a really short period of time for you to just track those hours and to pay yourself. But then the further along you get, it becomes really difficult to remember what happened. And it's your employer's responsibility to maintain those records and to give them to you whenever you request them. So the difficulty with not knowing or having certainty about what you were and weren't paid for is that if you do suspect an underpayment, it makes it more complicated to then assert those rights later on down the track. So in Australia, all employees, regardless of visa status, age, sex, race, any of those things, they're all entitled to minimum benefits and entitlements in the workplace. And so those entitlements and rules that regulate employment come from 4 places. The first thing is they come from the Fair Work laws. So there is a big, long piece of legislation called the Fair Work Act, and that sets out the minimum entitlements for all employees in Australia. And it includes in it the National Employment Standards, which are 11 minimum entitlements that have to be provided to all employees in Australia. The NES, or the National Employment Standards, cannot be excluded. So you can't contract away those rights. You can't sign a contract. Well, you can physically sign a contract that says, I agree not to be bound by the National Employment Standards, but that contract won't be worth anything and no court of law would uphold that contract. So the National Employment Standards would prevail. I'll explain a little bit more about those in a second. The next thing that we get our entitlements from are called awards. So modern awards are similar to legislation in that they're enforceable, but they're not set by Parliament. They're set by a body called the Fair Work Commission, and they are distinct pieces of law which regulate the rules and entitlements for people working in either a particular job or a particular industry. So we know that there are different standards depending on what industry you work in, for example, relating to ordinary hours of work. So the hours of someone working in an office, the normal hours, would be quite different to someone who's working in a restaurant. So the awards provide the rules and regulations and entitlements for people who are working in particular industries or jobs. So some awards are industry specific. So there is a banking and finance award. So that's for people who work in the banking and finance industry. And then there's also an award, for example, the Clerks Award. And that's an award for people who perform clerical or administrative work. And so that's regardless of the industry. It's just if you're performing that type of work, then you would probably be covered by that award. The next place that we get our entitlements from is a thing called an enterprise agreement. So a lot of people in Australia don't have an enterprise agreement. An enterprise agreement is sort of like an award, except instead of it applying to everyone in a particular industry or job, it applies to everyone in one workplace. So it's an agreement that is made between the employees and the employer about what sort of rights and entitlements everyone has. And then that agreement has to be approved by the Fair Work Commission. The agreement has to result in employees being better off than if they were covered by the underlying modern award. So it might vary things slightly in the award, but are more suited to the specific needs of that business. You can search on the Fair Work Commission website your employer's name under search agreements and see if there's an enterprise agreement that applies to you, although I would assume that in most cases, if you aren't aware of an enterprise agreement covering your employment, then there probably isn't one. But you can always check, because all enterprise agreements have to be approved by the Fair Work Commission, so they're publicly accessible. The final place that we get our entitlements and rights are employment contracts. In most cases, they're written, but they're not always written. Sometimes it can be a verbal contract. So a contract is just an agreement. It's an agreement between two parties, and it sets out what the expectations are and the duties are of each person in that relationship. So for example, you might have an award that says your minimum hourly rate is $28 an hour. But then you might have a contract that says that we agree to pay you $35 an hour. And like I discussed earlier on today, it would be the contractual amount that is owed because it's higher than. So whatever the more beneficial entitlement is, that's the one that you should be trying to enforce or that you should be sticking to. So going to the national employment standards, there are 11 of them, but I'm just pulling out a few that are relevant to underpayments specifically. So these are entitlements or rules that relate to every single employee in Australia. The first one is that full-time work means 38 hours a week plus reasonable additional hours. So as a full-time employee, you cannot be required to work 50 hours a week. That is illegal to require someone to work 50 hours a week. It might be that on a really busy week, say that you work in a shop and it's Christmas and Boxing Day week, that they need people to work late hours just for that 1 week. That might be reasonable considering the nature of that work, but you need to be paid for those hours. So you can't be required to, but you also have to, you can't unreasonably refuse not to work those hours, but you must be paid for them. The next thing is that there's no requirement to work in a public holiday. So if you're a permanent employee, then you should be receiving a paid day off work. Or if you're a casual employee, then you can't be required to work. Similarly to the full-time work and reasonable additional hours, depending on the nature of the business, your work can request that you work on a public holiday. And depending on the nature of the business, if it's reasonable, then they can request that. And an employee can only refuse that request if it's reasonable. So an example of when that request might be reasonable is if you work at a pub and they're open on Anzac Day because it's the busiest day of the year and they need you to work on the bar. So that might be a reasonable request, but you still need to be paid for it. And you need to be paid a very high rate to work on that day as well. The next thing is notice on termination. So the Fair Work Act in the National Employment Standards sets out a table of the weeks of notice that you're entitled to if you're fired from your employment. And so unless you've engaged in some sort of serious misconduct, which isn't the topic of today's talk, your employer has to give you notice. So they can't say, we don't really like your performance, can you finish up tomorrow? So if you've been working somewhere for a year, you work full time, then they need to give you the minimum notice that's set out in the Fair Work Act. And depending on how long you've been working there, the notice that you'll be entitled to will be between 1 and 5 weeks. And additionally, if you're over for 45 years old, then there'll be an extra amount of notice that you're entitled to. The next thing is redundancy pay. So if your employment ends because your role is redundant, so meaning the employer no longer requires anyone to perform the role that you're performing, as opposed to they just don't want you to perform it, so they actually are getting rid of the role itself, then you're entitled to an additional pay that's redundancy pay. Similarly to notice, it depends on how long you've been working on there, but it's between 4 and 16 weeks of pay in addition to your notice that you're entitled to. So the National Employment Standards also deal with leave entitlements. So I've got a little table up here which separates it into permanent employees, so that's full or part-time employees, and then casual employees. So permanent employees are entitled to 4 weeks of paid annual leave every year, and that amount is prorated if you're part-time. So if you work half of a normal full-time load, then you'd be entitled to 2 weeks of paid annual leave per year. Casual employees aren't entitled to annual leave. The next line is personal leave. So that's if you're unwell or you need to care for someone who's unwell or just needs you to care for them. So that could be a child or a dependent or a partner. You're allowed 10 days of paid leave in a year. And similarly, it's prorated if you're a part-time employee. The next category is compassionate leave. And that's leave that you take if someone in your immediate family is either very seriously unwell or has died. And you're allowed 2 days of leave per occasion. If you're a casual employee, you're allowed 2 days of leave, but it's not paid. The next category is family and domestic violence leave. And that's leave that you're entitled to if you need time off to deal with anything related to family and domestic violence. So it could be because you're actually fleeing an unsafe situation, or it could be that you're attending a counselling session to deal with the impact that the violence has had on your mental health. So you're allowed 10 days of paid leave per year, and that's the same for casual employees as well. So that's kind of a very novel type of leave, that you actually are paid that leave even if you're casual. The next thing is parental leave. So if you have caring responsibilities or you become pregnant, then after 12 months of service, you're entitled to 12 months of unpaid leave, and then that can be extended to 24 months if your employer agrees to it. Casual employees who have been regular and systematic casual employees, which it's difficult to summarize very quickly, but it means basically that despite being a casual employee, you've been performing really regularly for this employer for at least 12 months, then you're also entitled to the same leave as permanent employees. The final type of leave is unpaid carers leave, and that's to look after someone who might be sick or needs your care, and you're allowed 2 days of unpaid leave per occasion. And so that would be if you've exhausted your personal leave that's paid as a permanent employee, then you're still entitled to take 2 days of unpaid leave per occasion. Just going to have some water. Okay, so awards. Awards are a document, like I've said, that set out the specific minimum terms and conditions of employment for particular employees. And these are things that exist on top of the NES, or the National Employment Standards. So they build on those minimum entitlements. So they set out the rules for people depending on the industry or occupation, and they set conditions for employees in those jobs, including minimum rates of pay, hours of work, breaks, allowances, penalty rates, and overtime rules. So most people in Australia are covered by at least an award. People who are in senior management aren't covered by awards generally. So they're generally for people who are in the workforce and are not in senior management positions. Some employees are not covered by any award, so there isn't either an industrial or an occupational award that describes the situation that they're in. And then they'll be award free with NES, and the national minimum wage will still apply to them. So currently, until the 30th of June, and this changes every financial year, the minimum hourly rate for a permanent employee is $24.10. And the minimum hourly rate for a casual employee is $30.13. From the 1st of July, which is very soon, the minimum permanent rate will be $24.95 an hour, and the minimum casual rate will be $31.19 per hour. So minimum rates in modern awards usually are a little bit higher than the national minimum wage, but the national minimum wage is a really good touchstone to just quickly look at to assess if you think you might be underpaid. So if I have an employee comes to me and says that they're being paid $20 an hour, then I might not know the extent of the underpayment, but I'll know straight away that there is an underpayment. So I guess to bring all of this together, we're going to have a little look at a case study. And this is a scenario that I completely made up. So I'm not using anyone's real details, and the employer in this scenario is also made up. But the scenario itself is pretty common, I would say, and it happens a lot to a lot of different people that we provide advice and assistance to. So meet Fabiana. Fabiana found a job on Gumtree as a cleaner for Squeaky Clean Proprietary Limited. When she texted the boss, Greg, he told her that she could start working straight away, but because she had no prior cleaning experience, she would need to complete 5 unpaid trial shifts. Fabiana thought this was reasonable and agreed. Greg told her she would also have to pay $200 upfront to purchase the cleaning supplies for the work. She also agreed to this. Fabiana worked the trial shifts, which were each 7 hours long. After the final trial shift, Greg told her she had really proven herself and she would start to be paid. He told her that she would be paid a flat rate of $23 per hour, cash in hand, and that because their clients' needs change, her hours would change each week. He also told her that because most of their clients are corporate office spaces, she would usually get shifts on the weekend. She agreed to all of this. Fabiana has now been working at Squeaky Clean for 1 year and has never received a payslip or superannuation. So now, I apologize, we're changing the scenario to 3 months instead of 1 year, but let's look at the issues. So I've highlighted in red the things that are the red flags of the situation. So the things that stick out as being clearly unlawful. And then in orange, these are things that indicate to me what her entitlements possibly should be. So things that indicate maybe a different entitlement or something that dictates the way that her hours or pay should be calculated. So the red flags are that she was required to complete 5 unpaid trial shifts. So in Australia, it's a very common misconception that you can have unpaid trial shifts. That's wrong. It's unlawful not to pay someone for a trial. So even though you haven't committed to formally hiring them on an ongoing basis, if you require them to attend and you're benefiting from them attending, then you have to pay for them. You have to pay them for that work. The next thing is being required to pay $200 upfront to buy her own tools to carry out her work. So it's unlawful for an employer to require an employee to make a payment for the benefit of the employer. So this payment is for the benefit of the employer because it means that Fabiana is going to be able to carry out her work and earn money for the employer. So that's unlawful. She shouldn't be required to pay that amount. Another way that I see these unlawful requirements to spend or deductions manifesting is if someone in their employment damages some equipment at work. So let's say Fabiana didn't have to pay for the supplies up front, but she was using a mop one day and it snapped while she was working. If her boss then turned around and said, we're docking $50 from your pay for that mop, that would also be unlawful. So the other red flags are that she's paid a flat rate of $23 per hour. So that's clearly unlawful. It's under the minimum national wage, and that it's cash in hand. So it means that there's no tax and there's no superannuation. And we can see then further on below that she hasn't ever received a pay slip. So it will be difficult for her to track her hours and her pay. And she's never received superannuation. Now, the things that are highlighted in orange, there are 2 things. The first is that her hours would change. That's a good indicator that she's a casual employee. And casual employees are entitled to 25% loading on top of the minimum rate for a permanent employee. And that's in exchange for the fact that the work is insecure and unreliable, so your hours fluctuate. The other thing is that she was getting shifts on the weekend. So work on the weekend usually attracts some form of penalty rate, so a specific amount that you're entitled to for work performed at those times. Now, you do need to consult the award or find out if there is an award, because the rules about whether you get an extra amount on the weekend will change depending on the award that you're covered by. So let's help Fabiana figure out what's going on. So the first thing we need to do is find out whether there is an award that covers her employment. So what you can do is look up the Fair Work Ombudsman's Find My Award tool, and it's a really easy click-through application on the internet. You basically just type in what the role is that you're performing, and here you can see that I've clicked cleaner. So I started typing cleaner, and then that came up, and I clicked cleaner. And then it will ask what industry is the business in. And then I put contract cleaning. And also there's a drop down and I clicked contract cleaning. And then the tool has said, it looks like you're covered by the cleaning services award. And that sounds right. So the next thing is to find out what her proper entitlements are. So this screenshot is what the beginning of an award usually looks like. So on the left-hand side, you have a menu which has which you can use to click through the award and jump to different parts. And then on the right side, you can have, there are all these buttons here that provide various bits of different information. So as we discussed previously, the rates of pay change every year on the 1st of July. So if you click on the pay guides button, then you can have a look at what the pay guide was 3 years ago, and you can see what were the minimum applicable rates then, because sometimes an underpayment will have happened 4 years ago, and you want to know what the rate was then as opposed to what the rate is now. So once we have the award up, we need to figure out what her classification is. So a classification is a level that you are assessed as being at under an award. So there might be 3 different levels in an award so there are 3 levels that an employee might be classified at, depending on the type of work they're doing, the seniority that they have, the amount of people that they're training or supervising, the level of autonomy that they have in their role. And that will tell us what level they are, what classification, and each classification has a different pay rate. So the higher the classification, the more money you're entitled to generally. So to figure out classification, if you scroll on the left-hand side index, you can go all the way down to the bottom and you see Schedule A, and that'll usually contain the classification definitions. And so that'll have details of what the different classifications are. So in this scenario, let's imagine I spoke to Fabiana again and I said, what sort of things are you actually doing each day? Did you have to supervise anyone? Were you doing work on your own? What were you actually doing each day? And so she said to me, I worked on my own, but I didn't have to train anyone else. I was usually cleaning windows, cleaning bathrooms, and cleaning the carpets. And so I've gone and had a look through the different classifications, and I've seen that at a level 2 employee, a CSE, so cleaning services employee 2, they may be required to perform duties such as carpet cleaning. And so that's a pretty good indicator that she's probably classified as a level 2 employee under that award. So now we've figured out her classification and the award that covers her. We need to figure out what her correct pay is. So then on the left-hand side again, you want to scroll down to Schedule B, which has a summary of the hourly rates of pay. And there you can see that a level 2 employee has different rates of pay for day work, for early morning, afternoon, and non-permanent night shift work, for permanent night work, Saturday, Sunday, and public holiday work. So you know those are the minimum rates that she's entitled to for work that's performed at specific times. So what else do we need to check in the award? Because they're very long documents. The next thing you'll want to check is the ordinary hours. So they'll usually be set out in one of the clauses. So not one of the schedules, but one of the clauses. And that will set out what the normal spread of hours are in this type of work. In most awards, it's going to be 38 hours in a week, or the average of 38 hours in a week over a 4-week period. Anything that's beyond those hours will be considered overtime. So that's how you know what overtime is. The next thing to check is penalty rates. So you want to see what the special rates are for work performed at certain times, for example, after 6 p.m. or on a weekend. And so you'll be checking out what the award says about those entitlements and also speaking to Fabiana. So I might ask Fabiana, how many hours did you usually work in a week? And she might say, I only ever worked 25 hours in a week. That was the maximum. It was usually between 15 and 25. And then I know I don't need to consider overtime. Then I'd ask, what days were you working? she might say Thursday, Friday, Saturday, Sunday. And at what time? Always during the day. So I know that she's not going to be entitled to a nighttime penalty rate, but she's probably entitled to a weekend penalty rate. So let's put all of this together now. So Fabiana tells you that in the last 3 months, including the trial shift, she worked a total of 152 hours on Mondays to Fridays between 10 a.m. and 5 p.m., 74 hours on a Saturday between 10 a.m. and 5 p.m., 50 hours on Sundays between 10 a.m. and 5 p.m., and she never worked more than 7 hours in one shift. So she was paid $23 an hour, so we can work out that she received a total of $6,348. And it's also worth in these situations to actually check the bank account if they were being transferred by a bank, and just make sure that your client or yourself, that you were receiving the amounts that you thought you were receiving. The award tells us that she was actually entitled, and this is reference to this table here, that she was actually entitled to be paid $33.38 an hour for her Monday to Friday work, $46.73 an hour for her Saturday work, and $60.08 for her Sunday work. And so the total amount that she should have been paid is $11,535.78. So we can then know by putting those numbers together that she's been underpaid a total of $5,187.78. The next thing to consider is superannuation. So all employees, again, this is regardless of visa status, whether you're permanent or casual, all employees are entitled to be paid superannuation for ordinary hours of work. So this is anything that isn't overtime. The rate of the superannuation guarantee has changed every year for the past few years, but it's from the 1st of July, it's reached its peak, and it's unlikely to change, at least it's not supposed to change. There's no legislation on the horizon for it to change after that point of reaching 12%. But for the period that she was working, it was in the last financial year. So she was entitled to receive 11.5% on top of her wage in superannuation. So we also then know that she's been underpaid $1,326.61 in superannuation. All right, so we know that, oh, that's blank for some reason. Maybe I need to, sorry, 1 second. Oh, here we go. So what does Fabiana do to actually get her money back? We know that she's been underpaid now roughly around $6,500 in total. These are all of her options, and she might want to pursue various options at the same time. So she can write to her employer with a letter of demand. And this will generally, or in a lot of cases, if it's a reasonable employer and they didn't realize that they were doing the wrong thing, this is a really easy way to resolve the complaint. So you send a letter to your employer and you say, hey, I was being paid $23 an hour, but I've received some legal advice, and it turns out that I'm actually entitled to be paid $33 an hour. I've calculated that I've been underpaid this amount. Please pay me within the next 2 weeks, or else I might escalate the matter further. So that will resolve a good chunk of matters. A lot of employers don't realize that they're doing the wrong thing, and then once you tell them what's happened, they will rectify it. In a lot of situations as well, the employer doesn't care, and you need to take the next step, which would be going to court. Before going to court, you might want to consider making a complaint to the Fair Work Ombudsman. So the Ombudsman is the regulator, and they will investigate various complaints relating to underpayment. They may or may not investigate your complaint, and even if they do investigate your complaint, they may or may not take any further steps, such as prosecute on your behalf. So in my experience, the Ombudsman will generally pursue cases that are of a very high value or are systemic in some way. So where it's an employer who is underpaying lots of different employees. The other thing you can do for superannuation purposes is to make a complaint to the ATO, the Australian Tax Office, and you can make an anonymous complaint saying that you haven't been paid your superannuation, and then they chase that up for you. The final thing, which is something that you can and should do at any stage throughout taking any of these steps, or if you realize you've been underpaid, is to get legal advice. And so that's to speak to a lawyer and to get the specific advice about your situation. So the situation or the scenario that we just went through together is quite straightforward, but there are some things that can make a calculation of underpayment more tricky, like when breaks get involved, whether it's paid or unpaid, whether you're working a specific shift, whether the nature of your employment is contested, so whether you don't know if you were a casual or a permanent employee. So there are lots of things that can make the calculation a little bit more tricky. And you might want to get a lawyer, give a second opinion about your calculation or about whether or not you were underpaid. You also might want to get a lawyer involved to get some advice about how to actually pursue the matter in court. So let's say you've written to your employer, they say they don't owe you anything, you agreed to be paid this lower amount, and you might get a lawyer to come in and give you some advice about taking that next step of going to court. So going to court. These are the steps that are involved in actually going to court. So there are 3 different types of court that you can bring an underpayment claim to. You can go to the local court of New South Wales, the industrial court of New South Wales, or federal court. If, depending on the amount of the underpayment, you might be able to pursue the claim in the small claims division of that court. And so small claims divisions are for underpayments or recoveries of debts that aren't worth lots of money, and it's a really fast-tracked process. So, for example, the Federal Circuit and Family Court of Australia, the small claims division would deal with claims that are less than $100,000, and it's a process that's designed for people who don't have a lawyer representing them. The normal rules of evidence don't apply, so you don't need to be overly concerned about the form of your evidence and how you formatted everything. And usually the matter will be heard by a registrar as opposed to a judge, so it's a bit less formal than going through to a full court process. If you can't afford to lodge your claim, so most claims, or all claims, have a fee associated with filing the claim. The amount varies depending on the value of the claim or the court that you're lodging it in. If you can't afford it, there'll be a filing fee, a fee waiver form that you can file to try and not pay the amount. And so if you're in serious financial debt or hardship, then you can fill out that form, and in most situations they're very reasonable and they'll waive the amount so you don't have to pay it. The next thing you do after you've lodged your claim is to serve the claim on the other side. So you might have seen in American movies where people say you've been served. That's effectively what you need to do. If you're claiming against a company as opposed to an individual person, then usually just sending the letter to the registered business address is sufficient. But if it's an individual, then you actually need to hand it to them. But there are specific rules about how to effect service, and I recommend you speak to a lawyer if you have any questions about that. The next step, depending on in which forum you've brought your claim, is to attend some form of dispute resolution. So that could look like attending a mediation with the other side. So the court will say, we don't want you guys to go straight to a hearing. That's really formal. A lot of resources are going to go to that. Why don't you try have a mediation to settle the claim so that you don't have to go through this lengthy process. And so then the parties would get in a room together or be on the phone together and try to resolve the claim. So let's say the underpayment's worth $20,000. You might actually be willing to walk away for $17,000. And so you offer them $17,000 and you'll drop the claim. They agree to it and everyone walks away, maybe not thrilled, but happier than having to go through months-long litigation. Let's say it doesn't resolve at dispute resolution level, then you'll go through the formal hearing process of filing evidence and submissions. So it might be copies of pay slips or bank statements, a copy of the contract if you have one, and then your submissions that basically say, I was paid X, I should have been paid Y, I'm owed Z. Underpayment claims are fairly straightforward legally in the sense that in Australia, the minimum entitlements apply. There's no grey area. Then you'll have the hearing where each party will actually give their side of the story effectively, and then the judge or the registrar will make a decision and they'll say, either this person does owe you this money or this person doesn't, or they owe you this money, but actually only half of the amount that you've claimed for. Most employers, if you get to that stage, will actually agree to comply with the court order. So if the court says you need to pay this person $10,000, most people will then pay it. A small number of employers who are particularly unscrupulous will not comply with an order, and then you need to go down an enforcement process. So that's a process to force them to comply with the order. You should get legal advice definitely at that stage, because enforcement is quite tricky and it can also take quite a long time. But there are ways to try and force someone to comply with the court order that's been made in your favour. So before I hand over to some quick questions, I just briefly wanted to let you all know that with the Employment Rights Legal Service, we're a statewide service, and we assist particularly migrant workers, but anyone who is disadvantaged by the system, the legal system, and the structures that we have in place here. Anyone who earns under $70,000 and fits into those categories, we will assist. We don't assist employers. We don't assist people with workers' compensation or personal injury. We don't assist union members, and we don't assist independent contractors unless there is a suspicion that it's actually a sham contracting situation, which I discussed earlier on. So if you or anyone you know needs employment advice, then please make an inquiry. We have an online web form, or you can call us up as well. We have a phone line, and we should hopefully be able to assist you in a timely manner. I will now just go to the Q&A. Sorry, one second. Okay, if someone drove a vehicle such as a forklift at the employer's business and accidentally damaged the vehicle or other property, should the employee agree to reimburse the employer for the damage? I understand that the employer can only recover these costs if there is an agreement from the employee or there is a court judgment. Is that correct? So generally, the base rule is that an employee shouldn't be liable to pay any amounts, and if they're required to, then that's a breach of the laws. And that's even if the employee has agreed to do it. The only exception to an employee being directly liable for those costs is if they acted negligently. So if the way that they acted was really outside of their ordinary duties and responsibilities as an employee, and that's what caused the damage, then it would be their responsibility. So let's consider a car accident. If I take home my work car for the day and I hit someone else's car after hours, but I'm just driving to the shop after work, then I would have to pay for that because I shouldn't have been driving the car. It was not in line in the course of my duties, and it's not reasonable for the employer to pay for that. But let's say during work, my employer said to me, hey, can you pop down to the shops? We need some more paper for the printer. And I scraped someone's car on the way to Officeworks, then it would be unreasonable to make me pay for that. The next question is, how many times can you take compassionate leave in a year? I realize for each occasion you can take 2 paid days off. Yeah, so that's correct. Each occasion means that you get to take 2 days off. So I guess the idea behind it is there's no way to anticipate when someone close to you passes away or becomes seriously ill. And so each time that happens, your work has to let you take 2 days off, and it's paid if you're a permanent worker and it's unpaid if you're not a permanent worker. So if you're casual. We had a question about work from home entitlement. So can a manager say no to a request to work from home? Does it depend on the employer work from home policy? So this isn't specifically an underpayment issue. The short answer is that if you have a particular reason for needing to work from home, so let's say you have carers responsibilities or you have a disability that makes it difficult for you to attend the work every day, then unless the employer has a really good reason to require you to be in the office, then they have to let you work from home. So you'd have to apply for something that's called an individual flexible working arrangement. And that's something that, depending on your situations, you're entitled to request, and that the employer can't refuse unless there is a legitimate reason to do so. So if it's just that you like working from home, but there's nothing sort of deeper than that that's underlying that request, then it might be reasonable for the employer to require you to be in the office. But it really is a case-by-case basis. So I'd recommend that you get some legal advice. So Sunila again has said, how many times can you take compassionate leave? As many times as there is an incident. So there's no limit. It might be that in 1 year you take no compassionate leave because no one close to you passes away. But if 5 people pass away, then on each of those occasions, you can take 2 days of leave. So that would be, there's no limit of how many times you can take compassionate leave. How urgently can you provide advice to a client? I.e., if someone comes to us 5 days before they need to attend the Fair Work Commission, can we make a referral to your service? So we assess it on a case-by-case basis, and depending on our capacity, I would say definitely refer them through. We try really hard to prioritise people that have deadlines that are coming up. But if we're at capacity, we won't be able to assist, and we'll try to refer you to somewhere else that may be able to assist. And then I think this will be the last question, which is, if you go down the Fair Work Commission path and it does not work out, can you then go to the local court small claims path? So the Fair Work Commission itself actually doesn't deal with underpayment, so that's not one of the options for an underpayment claim. The Fair Work Commission deals with dismissal claims or award disputes, but they don't deal with underpayment. So I would recommend, if you have an underpayment, to proceed first either in the local court or in the Federal Circuit and Family Court Small Claims Division. That's all for today. So we're at 3. Thank you all for coming. If you have any questions or need any further advice, again, please fill out an inquiry form or give us a ring, and we'll try to be able to assist you in a timely manner. All right, thank you.